Terrific. We are now live on YouTube, and I'm going to let our folks in. Good evening, everyone. If you're just joining, welcome. This is the Renters Alliance Renter Town Hall. If you're just joining us, it takes a few minutes on Zoom to let everybody in, so we'll wait a few minutes, but welcome.
Thanks, David.
If you're just joining us, this is the Renters Alliance Renter Town Hall. We're just getting started. As with all Zoom or Renter Town Halls, it takes a couple of minutes to let everybody in, so we'll wait a few minutes. But if you're wondering why we're not talking, it's because we're waiting for people to come in. Welcome. We'll be getting started in just a couple of minutes. Welcome, everybody. If you're just joining us, we're just getting started. Good evening, everyone. We'll wait a couple of minutes, let people in. Thanks for coming. Give it one more minute and we'll get started. Okay, let's get started. Good evening, everyone. My name is Matt Losak. I'm the co-founder and executive director of the Montgomery County Renters Alliance. Tonight's Renter Town Hall is going to focus on two things in particular. One, we are hearing a lot about the double-digit rent increases that many people are facing. And we are also very interested in supporting the county executive's proposal, which went to the council yesterday for a 4.4% rent increase cap, or an anti-gouging rent increase cap. And that, as I say, was proposed to the council yesterday, and there will be a hearing for that on July 26th. I ask everybody who's a participant tonight, if you have questions or concerns, to put them in the chat. Our staff will address those concerns as we go. But those are the two main areas that we're going to focus on tonight. And of course, what we always focus on, which is addressing all of your questions and concerns about your renter experience, whether that be your leases, your rights, quality of life in your building, maintenance, and so forth. So if you have any of those issues, we will get to them during this Renter Town Hall. If you find that your question or concern was not addressed in the Renter Town Hall because we ran out of time, or you thought about it later, you can always email us at info@rentersalliance.org. So we're always very eager to address those concerns and inform you of your rights and sometimes your responsibilities as well. So I'm very pleased to have with us my staff. David Mullins, Malek Demir, and Pat Beckham, and as well as the vice chair of our board of directors, Chris Perry. And we are also delighted to have with us tonight, there's David doing double duty, probably triple duty. And we're delighted to have with us, as I'm saying, the new manager of the Office of Landlord and Tenant Affairs, Ms. Nicole Katrobanos. Nicole, why don't we just get right into it and have you take over and tell us where things are.
Sure. Thank you, Matt, and good evening, everybody. Thank you for attending and taking time to participate. My name is Nicole Katrobanos. I'm the new officer. I'm the new manager for the Office of Landlord Tenant Affairs. I am a Montgomery County resident. I've been residing here for 30 years. I am an attorney. I have worked in the legal world, litigating and civil matters, and representing clients in civil and circuit court, district court, and federal court for over 10 years. And prior to taking on this role with the Department of Housing, I was working at the District Court Help Center as a contractor for the District Court to provide free legal services to landlords and tenants on landlord-tenant disputes. So I'm very happy to now have this role with the Department of Housing and to be providing support to tenants and landlords in the community. And I'm happy to be here.
Terrific, Nicole. Well, why don't we go right into it? We had a list. You know what it is, so dive in.
Sure. So I wanted to take an opportunity first to talk to everyone about the Department of Housing and Community Affairs, the offices within the department, what we do, what services we can provide to tenants, and what our processes are. The most important offices that I think relate to landlord and tenant disputes are the Office of Code Enforcement and the Office of Landlord Tenant Affairs. These are two different departments within two different offices within the Department of Housing that have different functions and different processes. So first, I'm going to start talking about the Office of Code Enforcement. The primary function of the Office of Code Enforcement is to ensure that landlords are complying with housing and building maintenance standards, which in turn ensures safe housing and the repair of maintenance issues. So if you are a tenant and you have a maintenance or safety concern, and if the relief that you're seeking is solely to repair that issue so that the landlord is in compliance, you should be contacting the Office of Code Enforcement within the Department of Housing. And you can do that through 311. You can file a complaint through 311 with the Office of Code Enforcement. And you can also do it online on our website, which is www.montgomerycounty.gov/DHCA. And we'll put that in the chat. Now, how does the Office of Code Enforcement work? A tenant will file a complaint, either online or via 311, and then there will be an inspector from the Office of Code Enforcement that will contact the tenant with a date and time for the inspection. And usually those inspections are scheduled approximately 5 days after the complaint is filed. After that, the inspection will go, they'll inspect the property. They'll see if there's a violation. If there has been a violation found, then the property owner is required to correct the violation within a reasonable time, depending on the urgency of that violation. If it's not urgent, the time frame is typically about 2 weeks, sometimes 3, depending on the situation. If it is an urgent violation, meaning that it's unfit for human habitation, then the correction has to be done within 24 and 48 hours. So what kind of situations are considered urgent? It's emergency situations. They would be, heating, air conditioning, dangerous electrical wiring, some kind of severe infestation, gas leaks, excessive molds, etc. Once that's been identified by the inspector and once the property owner has been informed of the breach, then the inspector sets a date for reinspection to see if it's been remediated. If it hasn't, then the office can provide a civil citation, can issue a civil citation to the property owner, and usually they're about $500 and they're class A civil citations. And if after that it remains uncorrected, there can be a district court hearing so that it can obtain an abatement order and require corrective actions. So that's one avenue of relief, specifically for those tenants who only have safety and maintenance concerns, and that their only relief that they're asking for is that be repaired. Then you have the Office of Landlord-Tenant Affairs, and that is my office. And our primary focus is to help resolve disputes between landlords and tenants. And the type of matters that can be brought to our office vary. They can include maintenance issues. And if in addition to the repair of the maintenance issue, what you're searching for is, for example, a change of unit, or you're searching for a reduction of your rent, then it would be appropriate to file a complaint with us. And we in turn will inform code enforcement, and we will have two parallel complaints at the same time. Other types of legal issues that we address and that we assist with are security deposit complaints. For landlords and tenants, both landlords and tenants can file complaints with us. We also assist in breaches of lease. We also assist in early termination. If you're interested in terminating your lease early and you would like to know how to do that in a lawful manner and you would like to negotiate with your landlord, you can file a complaint with us. If you think you've been subject to any unlawful fees, we highly encourage that you file a complaint with the Office of Landlord-Tenant Affairs. If for some reason your rent ledger doesn't correctly reflect your payment history, you can provide assistance with that as well. So, and in general, any type of dispute that you have with your landlord or that the landlord has with you, we encourage parties to file. Our jurisdiction is limited in the sense that we cannot provide assistance to landlords or tenants that reside or that have properties in the city of Rockville, the city of Gaithersburg, or Tacoma Park. But all other zip codes, we can provide assistance. And as far as the service that my office offers, the Office of Landlord-Tenant Affairs, we have a number of investigators. When you file a complaint, your complaint will be assigned to an investigator. And that investigator serves as a neutral party. They will contact both parties. They will gather facts. They will then try to come to an agreement. They can set a number of conciliation meetings so that the landlord and the tenant can resolve their dispute and come to an amicable agreement with terms that both parties are comfortable with. If an agreement is reached, all the information shared in the conciliation meetings are private, so they can't be publicized, and there's no admission of guilt. And that's one of the functions of what an investigator can do. So they can issue what's called a determination letter determining what the results are. They can issue an agreement where it's a signed agreement of what both parties will agree to do. And if the facts aren't clear, if there is a question of law and an agreement isn't arrived by both parties, then the investigator can recommend that case to the Commission of Landlord and Tenant Affairs. And the commission is essentially a quasi-judicial body. And the case will be referred. The commission will decide if they're going to take the case or not. And if they do decide to take the case, then there's a full hearing that's held. And in that hearing, parties can testify, evidence can be presented, and the panel of commissioners will make a determination that has the same exact impact and as if it were in district court. So the main purpose is to try to mediate. If mediation can happen, there is the option of there being a trial, and parties can choose or not choose to be represented. One of the benefits of having a hearing with our commission versus having a hearing in district court is that it is typically more affordable. In district court, there are a number of fees that you have to pay. There are no fees that are incurred if you file with the Office of Landlord Tenant Affairs. And it is a little bit less informal, which means it can be a little less intimidating for those individuals who are not accustomed to the legal processes of court. So that is a summary of the functions of both the offices within the Department of Housing, first being the Office of Code Enforcement, and the latter being the Office of Landlord Tenant Affairs, which is the office that I manage.
So Nicole, if I would jump in and give a layman's quick interpretation again of what I think you just said, and correct me when and if I'm wrong. Code enforcement for maintenance issues, okay? Broken refrigerator, mice and vermin, anything having to do with what Nicole mentioned before, electrical problems, gas problems. And by the way, if it's a life safety issue, as Ms. Katrobanos just pointed out, some of these things shouldn't wait. If you feel that your life is in danger, obviously you need to call 911. If you smell gas, you need to immediately report that to 911. If there's a fire, you call 911. Some of these things need to happen immediately. If you feel that your life is in danger because the air conditioning is not working and it's 95 degrees outside and you feel that you might be at risk for your health, you may need to call 911 first if you cannot get that repaired immediately. So think about life safety issues as emergency. Absent an emergency, maintenance issues, repairs of appliances, broken windows, broken doors, that's a code enforcement issue. Is that about right, Nicole?
That's right.
Okay, we're in agreement. And the second is any kind of issue with your rights, a disagreement about your lease, or the promised or required services that you think you're not getting in your apartment community after, in both cases, code and in rights and leases, you've gone to the property management or you've gone to the landlord and said, hey, we've got a problem, let's work it out. And if you feel that that doesn't happen in a timely fashion or in an acceptable fashion, then you need to file a complaint with the Office of Landlord and Tenant Affairs. Now, I will say also that we're value added in this process. If you're not sure, we can advise you. We've been doing this a long time. We know when, we can give you some first aid advice or whether we need to send you to the doctor, okay? So feel free to contact us at info@Renters Alliance if you're not sure. Anyway, that's where we are now.
Matt, I'd also like to comment that in addition to filing a complaint, if you also just want information and you'd like to speak with one of our investigators, you can call 311. You can ask to speak with the Office of Landlord Tenant Affairs. Then you will speak with an agent. They'll see if they can answer your questions. And if they can't, you will leave a message with your name and your phone number. And within 24 to 48 hours, you will have someone that specializes on the subject call you back to answer any questions you may have, to see how the law applies to you and see what your options are. Another alternative is that you can email our office directly and get a response directly from one of our investigators if you just have general questions and you're not ready to file a complaint or you don't know if you should file a complaint. And you can do that via our email, which is olta, O-L-T-A, .intake@montgomerycountymd.gov. And again, we typically respond within 24 to 48 hours.
Okay, I put those links in the chat. Another valuable piece of information for every tenant is the county's Office of Landlord and Tenant Affairs Landlord Tenant Handbook. If you want to understand your rights, basic rights, remember there's two sets of laws that we're operating in, three really, but federal obviously, but state law and county law. Montgomery County law with regard to landlord tenant is usually a little bit better than the state law. Good to read the Landlord Tenant Handbook, which the Renters Alliance was proud to be a part editor of, and make sure that you know what the process is and what your rights are. As I say, contact, as Nicole says, their office through ulta.intake@montgomerycountymd.gov. I put the link in the chat, or you can call 311. We'll address some of your questions and concerns shortly, but we have a couple other issues that we want to go through. Nicole, do you want to dive into that?
Sure. So I know one of the main concerns that tenants have right now has to do with rent increase. And many of you have received rent increase notices. And I wanted to say that our office, the Office of Landlord and Tenant Affairs, is here to support you throughout this process. We have received a number of complaints and a number of emails informing us of these rent increases. And we have been compiling data based on the complaints that we have received. And the rent increases that tenants have notified to us, which is just a sample, it's not a survey, so it's not indicative of everything that's happening in the county. But the information that we have received is that the rent increase notices that have been reported vary anywhere from 5% up to 74 and 90%, specifically when leases go on month to month. So this is obviously impacting tenants significantly. It's resulting in tenants self-evicting, being evicted, being displaced, and that of course has a number of other, domino effect and impact. So for those of you who have been subject to rent increase notices, we are asking that you please contact our office. Ideally, contact us via email and send us a copy of your notice. There are multiple reasons why we're asking you to do that. One, we want to document everything because it's important. Two, we wanted to have the opportunity to review your rent increase notice. County law has a number of requirements of how that notice needs to be provided to the tenant and what information needs to be provided to the tenant. And from the complaints that our office received, we have noticed that there are a number of landlords that are providing defective notices. Now, what does this mean in short term and long term? Short term, it means if you provide us a copy of that notice, if we identify that it's defective, and if you open a complaint with us, we can contact the landlord. We can inform the landlord of the defectivity and that it's defective. And then we can ask and require the landlord to issue a new notice. What does that do? Short term, it buys you more time. And 3 or 4 months can make a big difference. Long term, what we can also do is that we can try to mediate. Obviously, since at this point, there hasn't been a bill that's passed with an extension of the rent cap, we don't have a law to fall back on, but we can do everything in our power to contact the landlords on behalf of the tenants, see the reason behind the rent increase, see if they're open to reducing the percentage of rent increase, and or distributing that rent increase in a longer period of time so it's more palatable to the tenant.
Nicole, let me jump in and address something that comes up and to repeat what you just said again for people like me who are not lawyers. There is, as Nicole just said, Ms. Katrobanos, there is a law in Montgomery County that says a rent renewal notice, a rent increase notice, a rent renewal notice has to contain certain elements by law. One of those elements is your current rent. Another element is what the increase is going to be and what the percentage of that increase is going to be. It also has to include a statement saying what the county's voluntary rent increase guidelines are. That it's voluntary, but they still have to tell you what they are. Right now it's 0.4%, 0.4%. It also has to include a statement that if you disagree with this rent increase or have an issue with it, you can contact the Office of Landlord and Tenant Affairs. And it also has to include a 2-year lease option unless you are in an annual financial certification program. Then they can offer you a 1-year lease. We disagree with that, but that's part of our struggle. But that's the way it is now. If you are annually certified for financial status, they only have to give you a 1-year option. If you are not annually certified in a commercial property, they have to give you a 2-year lease offer. If they don't give you those things, and in the format that Ms. Katrobanos just outlined, the lease is defective. Somebody said, what does that mean? That means it's not legally valid. And so if a complaint is made, the Office of Landlord and Tenant Affairs will then require the landlord to reissue the renewal notice. The renewal notice must be 90 days prospective. That is, your increase cannot take effect for 90 days. If you have paid, say you got a renewal notice 3 months ago, and you found out that the renewal was defective and the increase was 5, 10, 20, whatever it is, whatever the increase is, the landlord, when they reissue the renewal notice, will still have to credit forward any increase that you paid on the defective renewal notice from the time when they issued it. So that there is some benefit to keeping your eye on these things. The Renters Alliance fought very hard to make sure that these elements are in your renewal notice, and we want to make sure that you get your rights enforced.
Correct.
Okay, why don't we talk about, if there's nothing else on that front, Nicole, what about this legislation?
So, as many of you may know, the rent cap legislation, or Bill 2222, was introduced yesterday, Tuesday, July 12th. And there's a hearing scheduled for the 26th of July, which is a Tuesday. Basically, what it proposes is that for 6 months, once it's been approved, if it's approved, that there be a rent cap of 4.4%. That means that if it's approved, tenants would essentially be protected with a 4.4% rent cap for 9 months after the legislation is approved. Why 9 months? Because you have the 6 months that's proposed in the legislation, plus landlords are obligated to provide tenants a 3-month or 90-day rent increase notice. So the 3 plus the 6 equals 9. It could potentially cap rents at 4.4% for 9 months.
Some people are asking, well, it will cover what it will do to people who already received these rent increases. Can you explain the language in the bill in terms of whether or not it will affect them?
So laws cannot be applied retroactively, right? But because there is that 90-day rent increase notice requirement, if the 90 days haven't passed, and if the law is passed during those 90 days, then the notice becomes void. Is that clear?
Yeah, and I am just pulling up the bill so people can read the language themselves. Trusting I'm not on mute here. Hang on 1 sec, I'm not on mute. So here comes the bill. This is a very important element and matters to everything that we're discussing tonight. Here's the bill. It's Bill 2222. Hang on, getting it there. Fingers don't work as well as they used to. Hang on. Okay, there's the bill if you want to read it. I want to go over that again. There's a couple of strategic things that all of you need to know, and we need to share with our neighbors and across Montgomery County. If this bill does not pass by the end of July, and the hearing is on the 26th, then it will not affect all of you who have received excessive rent increases over 4.4%. If it does pass by the 26th, when the hearing is, and the council is to vote on it before the end of July, then, as Ms. Katrobanos points out, the law says, and Nicole, maybe you can explain this or say the actual piece of language, but the law says that any increase that has occurred during this, since your increase was given to you 90 days perspective, that is, it hasn't kicked in yet, then this law will apply to those increases. and any increase over 4.4%, if the law passes, will have to be brought down to 4.4%. Now, I know the Renters Alliance thinks 4.4% is a high increase anyway, but it's not nearly as bad as 6, 7, 10. And I have to say, if I've gotten any redder, it's because Nicole has just informed us of rent increases 70 to 90%, which is blowing my mind because the last one we saw was 53%, which was enough to blow my mind. Now, hearing that we're seeing those kinds of increases, it's just beyond outrageous to us. If you're in this boat, and we know that a 5% rent increase, 6%, 7% is enough to maybe price people out of the homes themselves with just that. But if you're in this boat, we need to know about it. And we need to also, and I can say this from the Renters Alliance standpoint, to prepare testimony, to write letters, and to communicate with the council that this is critically important to maintaining stable, affordable, quality homes in Montgomery County, especially for working families and low-income families. But we've seen increases with middle income and higher income families, and especially seniors. So you might be a well-to-do senior, but if you get a 10%, 20%, 30% rent increase or higher, you're not going to be able to stay in your home for much longer, probably. So the impact on our communities for creating what we believe will be a forced migration of renting families, particularly working and low-income families in Montgomery County, will be a disaster in the long run. Now, we're not alone. This is happening nationally, but the only way that we as renters and citizens can do anything about it is to influence our government with these stories and require that they act on it. One other thing, Nicole, that correct me if I'm wrong, but this is only a temporary measure. Do you want to explain that?
Correct. So it's only being proposed for 6 months. And as I mentioned earlier, because of the 90-day notice requirement, after the 6 months, if landlords want to increase the rent, they would have to provide a 90-day rent increase notice, which essentially provides a protection for 9 months for tenants after the passing of the bill. After that, we will be essentially in the same situation that we are now.
Except that if you sign a 2-year lease at a 4.4% rent cap, you'll be good for 2 years if it passes.
Yeah.
So it will provide a measure of stability for a period of time. And God willing, and a little bit of luck, and we'll see what the inflation rate in the United States ends up being, and so on and so forth, maybe some of these impacts will be reduced over time. We're all suffering from a couple of things that are somewhat beyond our control. One of them was the COVID pandemic, which put many people out of work or reduced their hours and their incomes. The county and the state, and with the federal government's contribution, was able to put out a significant millions of dollars, frankly, in rental assistance for people struggling. Wasn't enough, but it was helpful. We have managed to have a rent stabilization program in effect that went on through May 15th. That was helpful. As I say, we recognize that a 4.4% increase is still a heavy lift, but we also recognize, in fairness, that landlords are also seeing these inflation rates, and they have some overhead that is reasonable to expect that they need to keep up with. So the county's voluntary rent increase guideline is 0.4%, and the rent cap that expired May 15th was at 0.4%. And you can imagine that if you're a landlord having to look at fuel prices or electrical prices or even staffing, that was quite a cap. Now, we felt that it was justified because everybody's struggling, landlords and tenants, and that these were emergency measures to keep people stable, not just for affordability and financial reasons, but because COVID required that we stay in our homes and remain as stable as possible to avoid virus spread. Now we've got a vaccine. Hopefully everyone out there is vaccinated. We urge you to do so. Rent relief has gone out the door to a great number of people. And people are going back to work because of the vaccines and because we're getting our handle on it somewhat. But inflation is still a severe problem. And those people who have been struggling are not completely on their feet yet. And senior citizens, which I believe is the sleeping tiger here, no matter where you are on the economic spectrum, most seniors are on fixed incomes. And so when your housing costs are going above 30%, 40%, 50% or higher of your income, you're going to start choosing between food and medicine and your housing. And that's just not sustainable for senior citizens, especially the increasing number of senior citizens in Montgomery County who are 70, 80, or 90 years old. Moving for me was terrible when I was in college and just had to move from dorm to dorm. But for people who live in their homes for many years, who live there lock, stock, and barrel with all their belongings, the thought of having to find someplace else to move is overwhelming. And now we know there aren't a lot of choices either. So where are you going to go from one place to find someplace more affordable, especially in the community where you have roots and family relationships and your home? That is very, very difficult. So we are urging everyone to please pay attention to this bill and to contact your council members. I'll put the link to the Montgomery County Council in the chat. And if you've received one of these rent increases, we urge you to contact us and we'll make sure, if you're willing, to testify before the council on July 26th. So anything else, Nicole?
I did want to address a little bit other services available for tenants that find themselves in these difficult situations. While the COVID rent relief program phase 4 has closed, for the applicants that are still pending, if you have a COVID rent relief application pending, and if you're in an imminent situation of getting evicted, meaning that you've gone to court and you've had a judgment entered against you, or you've received a red and white notice from the sheriff's office, please contact 311. Please email the HHS email address with a copy of that documentation so that they can expedite your application. Also, if you're in court proceedings right now, you can file a motion to stay the eviction. And there's the district court help center where there's attorneys that can help you file and do that. You can call them at 410-260-1392, and they're located on the second floor of the Rockville District Court. In addition to the COVID rent relief funds, DHHS also has a separate funds called Housing Stabilization Funds. So if you didn't qualify for COVID rent relief, or you weren't able to apply for COVID rent relief, and you are in an imminent situation of getting evicted and you need assistance finding housing, or you need financial assistance to help to pay the security deposit at your new place, please call 311. Please call and ask for housing stabilization. You will get a call back and you will be assigned to an individual who will work with other county organizations to try to assist you in finding housing and to provide a one-time emergency assistance, financial assistance.
So I'm just looking to put up one of the link, perhaps Malek or David, if you could, or Pat, if you could find that and put that in the chat. Let's address a couple other things, Nicole, since we're into some specifics. One is a reminder: you can only receive a rent increase once in 12 months. So if somebody asked the question, can I receive a rent increase before my lease expires? Well, you can receive the increase, but it can't take effect until after your lease expires and not for 90 days from the renewal notice. So keep that in mind. People who are on month-to-month leases, they can't increase your rent each month. They can only do it once in a 12-month period. For people whose leases have expired and they did not receive a renewal notice, then you are automatically, by state law, month-to-month. But if you don't receive a renewal notice, your rent must stay the same. Is that correct, Nicole?
That's correct.
Thank you. I'm just checking to see if I still have my marbles because I'm not 100% sure. So that's very important. And also this comes up from time to time, and we like to keep reminding people, Nicole, if you would go through what is required to evict somebody.
So what happens often is a landlord provides a notice to vacate the tenant, stating, we're requiring you to vacate for XYZ reason. It could be for not paying the rent, for breaching the lease, and you have to leave by X date. And tenants are incorrectly assuming that that's an eviction notice. That's merely the landlord informing you of their position and basically saying if you don't move out by that date, they will file a court action against you. In order for you to be evicted, you have to have a hearing date, you have to have your date in court, and afterwards a sheriff has to schedule an eviction and you will receive a red and white notice on your door. Some of you may know, court processes can be lengthy. They do take some time, so it can take several months from the date that a case is filed to the date where an eviction will actually be scheduled. And during that time, depending on the type of case that you have, there could be potential different remedies. So a landlord cannot lock you out of the house. They cannot cut access to your water or electricity, or essentially illegally evicting you. And you do not have to self-evict unless you get to the point where you have an eviction notice scheduled by the sheriff on your door.
And let's go a couple more steps into that. So you receive your 10-day notice from the court. I'm proud to say, despite the confusion over it, that the Renters Alliance was instrumental in getting that law passed. It used to be you could get a court summons and have to be in court in a couple of days. Now we passed a law, state law, that says the landlord has to give you a court form that says we're going to file in 10 days.
That's
so now you have 10 days
for failure to pay rent cases.
For failure to pay rent. Thank you. And so now you have 10 days notice that the landlord intends to file with the court. Then the landlord will file with the court and you will receive, and Nicole, monitor as I go, interrupt me when I'm wrong, that you will receive a court summons. The court summons will give you a court date.
Correct.
We urge you, please don't ever miss a court date, okay? If you have to go to court, go. If you're right, especially, and you don't show up, you will have a judgment against you that will count on your record and of course lead to eviction because you will have provided no defense. We also urge you to reach out to us for guidance. We can tell you, what your options might be if you receive that. So you receive a court summons, you go to court. If there is a judgment against you, Nicole, maybe you'll take us from there.
Sure. So if a judgment is entered against you, then afterwards, 10 days afterwards, typically, the landlord has to file what's called a warrant of restitution with the court. That warrant of restitution then needs to be signed by a judge, and then it needs to be sent to the sheriff's office. At that point, the sheriff's office will then schedule an eviction, and you will receive a red and white notice on your door. So from the date that a judgment is entered to the date where an eviction is actually scheduled, it can easily be anywhere between a month or two.
If you're lucky, but we urge you to get in touch with us immediately. Do not wait. If you think you're going to court and you think you're going to lose your housing, there's assistance for you. There's guidance for you. There may even be financial resources, though not guaranteed. But contact us early. Don't wait and let this fester. When you get that red and white on your door, eviction is imminent. Could be weeks, could be longer, but you better count on it being imminent. And you don't want to have it. Once a sheriff arrives at your door with the property manager, they are going to be authorized to put your belongings on the street and lock your door. So let's not get to that point. Now,
and specifically for failure to pay rent cases, it's important for all tenants to know you have up until the date of your scheduled eviction to pay for the amount of rent that's on your judgment to be able to stay. Now, the amount of rent that's on your judgment may not be the same amount as the amount of rent that you owe, because it all depends on what the landlord filed. So let's say, for example, the landlord filed a failure to pay rent for January up until March. And then your hearing date is in May. And then your scheduled eviction is in June. The money that you owe, based on what the judge signs, more than likely will only be the rent that was due from January up until April, the date that they filed, not necessarily all the money that you owe to the date of the eviction.
So
And
you
you
can
have-
pay that amount
Mhm.
and stay, and then the landlord will have to refile. So this
Correct.
will allow you some more time to earn some more money, to pay it down, or consider other options.
Correct. And that's why it's so important, if you do have a COVID rent relief application pending, and if you are in court proceedings, and if you have received a judgment or red and white notice, that you inform HHS and give copy of those documentation so they can expedite your application and be able to pay the landlord.
And if it looks like you're not going to receive COVID rent relief because you don't qualify, because you're behind in your rent for other reasons other than COVID impacts, or you didn't apply for the rent relief or whatever, but you're facing eviction anyway, there are other resources.
Correct. Housing Stabilization has issued award letters, working with other community partners and working with county funds to many individuals that did not qualify for COVID rent relief, and has assisted them in a transitionary period so they don't get evicted.
Now, something else that comes up. Can you go through what happens to what rights a tenant has in the event that a landlord or property manager attempts to evict a tenant without a court order?
Well, what we encourage people to do, if that's the case, is to call the police and contact their office, and we can contact the landlord to remind them of what their obligations are and what the legal processes are. If you feel as a tenant that you're being harassed by your landlord, you can always go to district court during court hours or after court hours at the commissioner's office and file a peace order against your landlord. And when I was working at the district court, I saw a number of peace orders that were granted in those types of situations. And in addition, if for some reason you do get illegally evicted, your locks are changed, the keys are changed, and you have to incur expenses such as staying at a hotel or, paying for food at restaurant or whatnot. You can always file a claim in district court, a small claim or a large claim for the cost incurred as a result of the illegal eviction. And there are attorneys at the district court help center that can guide you through that process at the phone number that I listed earlier.
So what that means is if you're facing eviction or your landlord wants you out, they can't come into your house and move your furniture around. They can't change the locks. They can't turn off your water or your electricity. They can't reduce your services. They can't harass you in any way until the court orders it and they arrive with the sheriff. Other than that, your apartment is still your private home. They can't barge into your apartment and they can't harass you. Some of the harassment we've seen would be like a poster on your door, not an official notice like the 10-day notice or the court summons. But if they start putting a poster on your door, like people who live here are deadbeats, or you owe us money, and if you don't leave soon, we're going to do whatever. If that happens, we want to know about that. And the Office of Landlord and Tenant Affairs can also intervene. But as Ms. Katrobanos just mentioned, if somebody comes into your house without authorization and attempts to do any of that, consider it your private property and call the police. They are trespassing until they're authorized to come in. Believe it or not, we've seen this. It often happens with smaller landlords who don't know the law, but we've also seen it with larger corporations that have property managers who don't know the law or who just get very heavy-handed. And it is absolutely unacceptable. So there is a court process, a judicial process in place that is meant to protect your rights, and we insist that it be followed. So let us know if you have any concerns in that regard. Staff, sorry, Nicole, is there anything else you'd like to add in that regard?
No, that's it.
Staff, do we have any other questions or concerns in the chat that I have not seen?
Yes, Nicole, can you give us an idea? There are so many people in the community waiting to receive their COVID relief money. and I know you don't have an exact date or anything, but where are we in the process of people receiving money? Is it moving along fairly rapid, or there are just a lot of people waiting to hear or receive their money? And I was just wondering how the process was going.
So the Department of Health and Human Services obviously have all applications as a #1 priority, and they have all their staff working at full capacity to get those applications out and awarded as soon as possible. I will say that they have received a total of 3,500 applications during phase 4, and they're expecting the funds to be fully committed with these applications. So if you go onto the website, it has details regarding the process and any general questions that people may have, but there's nothing that, I mean, at this point, people just have to wait. And unless an emergency situation occurs, the way I mentioned earlier, if they're about to get evicted, then they should contact DHHS.
Thank you.
You're welcome.
I want to emphasize something for those of you who are waiting. The Health and Human Services Department, from all of these programs, from the beginning to the current program, phase 4 of the COVID rent relief program, has been prioritizing those applications as they're moving through all of them that are getting closer to eviction. So if you've received a court summons that you had not received prior to applying for COVID rent relief, but now you've received a court summons, they need to know. If you've received, God forbid, a red and white that says that you're heading to eviction, then you need to let them know. And you do that by emailing them at hss@montgomerycountymd.gov. HSS. I know that's counterintuitive to HHS, so I don't want to confuse you any more than you already are, but HSS, for those of you who are moving closer to eviction and need to inform the COVID rent relief people that your eviction is becoming more imminent. They are working to prioritize those applications when they know about it. For those of you who are denied COVID rent relief funds, but feel that there's a mistake that's been made, or there's some other difficulty with that, HHS are human beings, they're struggling, some of them get confused, there are mistakes from time to time. Let us know. We are very good at navigating county government and making sure that people's rent relief is provided when they are entitled to it. So please let us know. That's what Renters Alliance is here to help you with as well. What else, staff? Anything else we see? Malek, I saw you pop up. What else are we seeing?
I think we're good, actually. Yeah.
All right. If you have any questions or concern, we'll give you another minute or so to put it in the chat, and we'll address it. If it looks like we've hit all of our points, we'll come to a close on this beautiful summer evening.
Just give me a second.
Someone asked in the chat to confirm once passed, the legislation will offer protection over all rent increases that have not taken effect yet.
Yeah.
I want to be specific, since if you received already a rent increase prior to May 15th, it should have been at 0.4%. After May 15th, if my dates are right, Nicole, you'll still be in the 90-day prospective period. And this law will cover any rent increase that has not yet taken effect. So that if the dates are right, that means this legislation will have to pass by July 30th in order to protect and reduce the increases of those who have gotten them since May 15th.
Correct. And if it passes, all landlords will have to either amend their rent increase notices to be 4.4% or lower, or they'll have to basically rescind them.
Right. Very, very important. Again, this is not normal times. And the Renters Alliance has been around since 2010. We're the first and only regional nonprofit dedicated exclusively to renter outreach, education, organizing, and advocacy. And we have never seen these kind of increases before. We believe based on our considered opinion, that we're seeing a crisis. Because we're not alone in that crisis doesn't make it any better. People in Prince George's County, Baltimore are seeing severe rent increases, and we're seeing it across the country. We think something needs to be done through our government legislatively in order to balance a landlord's reasonable interest to make the profit and keep their profit and to keep up with expenses. But we don't believe it's an opportunity for rent gouging and profit increases at the expense of whole communities. What people often don't realize is that they think it's just going to hurt the one family that moves out. No, there are other costs that we will all pay. Financial costs and increased crime, healthcare costs for people who are suffering mental and physical issues because of having to move and being forced to move. Students who will not achieve academically because they're constantly worried about losing their home or being forced to go from school to school because they do lose their home. We are going to see a reduction in prosperity. When people are permanent and stable in their homes, they participate economically and socially and politically in their communities differently from those who are never sure if they're going to be able to stay where they are. So for those who have cold hearts and think, well, tough, you couldn't afford it, goodbye. Believe me, we're all going to pay for that. And the numbers that we're talking about are not insignificant. Ms. Katrobanos pointed out that they've received what about 50 to 100 complaints so far?
Our office has received 60%, and we have, 60 complaints. And but you have to remember, if one tenant is filing a complaint and they have a unit in a multi-family unit where there could be 100 different units, and if half of those individuals are also receiving rent increasing, it's reflective of a lot of increases in the community.
So this is the tip of the iceberg, we believe. And so very concerned about it. And we are already, prior to the pandemic, seeing people being priced out of their homes, particularly working class and low income, but seniors, I keep emphasizing that, who are paying more than half their income to be able to maintain their housing. So looks like we're coming to an end here. I don't see any other questions or concerns in the chat. So I'm going to say, if you have any and you think of it later, you can contact us at info@rentersalliance.org. We're here to help. We have staff who are here to help. We will be putting out more information about the hearing coming up on the 26th. If you'd like to testify, please contact us at info@rentersalliance.org. If you've received an excessive rent increase or a defective rent increase renewal notice, please let us know, or we'd like you to do both. Contact the Office of Landlord and Tenant Affairs at ulta.intake@montgomerycountymd.gov. Let us know about it. And we have also heard a concern that we'll address perhaps next Renter Town Hall or down the road, that there are a significant number of people who are on housing vouchers from the Housing Opportunities Commission, which administers the Housing Choice Voucher Program, that they're seeing increases that go beyond what their vouchers are willing to pay. And so that whole community is also facing, and this is a particularly vulnerable community, is facing the possibility of having a wholesale forced migration of those folks. So we're going to ask HOC to join us in a future town hall, and we'll get to those questions and concerns as well. So again, thank you very much to our new manager of the Office of Landlord and Tenant Affairs, Nicole Katrobanos, for her very informed, knowledgeable perspective and information. I want to thank our staff, Pat Beckham, David Mullins, and Malek Demir, and my watchdog, my vice chair of the Renters Alliance Board of Directors, Chris Perry. And with that, this was recorded. It is on YouTube. We'll put it out in our next newsletter. If you've registered for this town hall, you will be in our database and receive our next newsletter. So thank you all for joining, and good night.